May it please the court, Mr. Brister will present argument for petitioner. Mr. LaFond will present argument for the amicus. Petitioner has reserved 5 minutes for rebuttal. Mr. Brister will open with the first 10 minutes and will present the rebuttal.
May it please the court. Scott Brister with Hunt and Andrews Kurth, representing the San Jacinto River Authority, the government entity responsible for operating the dam on the San Jacinto West Fork of the San Jacinto River that forms Lake Conroe, one of the larger lakes in the state. Hurricane Harvey struck southeast Texas in August of 2017. According to the Houston Chronicle, flooded over 150,000 homes in Harris County alone. About 2,000 people filed some 40 lawsuits claiming their homes flooded either because the River Authority released too little water from Lake Conroe before the storm hit or released too much water from Lake Conroe after it hit. In the 3 cases before the court, there are 47 plaintiffs. The Court of Appeals dismissed their constitutional takings claims for refiling in the Harris County civil courts where they remain pending, and there's been no appeal from that order. But the Court of Appeals refused to dismiss their statutory takings claims under Chapter 2007 of the Texas Government Code, and that was error for 3 reasons. Number 1, Chapter 2007 applies only to regulatory takings. Plaintiffs concede they don't allege a regulatory taking. Number 2, Chapter 2007 does not apply to emergencies. In fact, it's impossible to comply with the statute in any and all emergencies. And number 3, Chapter 2007 waives immunity only for suits to invalidate or rescind regulations. You can't rescind a flood or a hurricane. The statute doesn't apply because the plaintiffs don't seek to rescind or invalidate, they seek only money damages. Let me turn first to the text of the statute. I've filed the bench exhibits that have the relevant text for you. You could turn to Exhibit A. The legislature helpfully starts off in Section .003 by saying this chapter applies only to the following governmental actions and lists a long list. The parties agree that every one of these items is a regulatory, relates to a regulatory action or a regulatory taking. With exception of 1, physical invasion, which I've highlighted in Part A2. But the parties agree on that one. It can refer also to a regulatory taking, but also to a physical taking. And of course, there's, just to cite a few famous cases, a regulatory taking can cause a physical invasion. For example, in City of Keller versus Wilson, the government's revised their master drainage plan so that it flooded the plaintiff's property. That's a physical invasion of property as a result of a regulatory action. So the question is, should physical invasion, the one term at issue, be given a related meaning to all the other items in the list, ordinances, rules, regulations, policies, guidelines, permitting, citations, orders, or should it be given a meaning that's entirely different and sweeps in every kind of taking? So really the legislature was just wasting their time detailing all the regulatory items because physical invasion was intended to bring in everything. As Judge Greenhill wrote 40 years ago in the Riverside National Bank case, words grouped in a list should be given related meaning. That's why we believe physical invasion, which is conceded can mean a regulatory taking, should be construed just the same, related to every other term in the list, and it applies only to list.
Mr. Brister, but when you look at the statute as a whole, isn't it clear that the legislature intended physical takings to be included?
No, and the context I'll go to on tab D has to do with remedies, and that context shows, in fact, they did not. Because in tab D, the remedies are limited. Section .023 says if the trier fact finds there's a taking, then the private real property owner is only entitled to, and the governmental entity is only liable for, invalidation of the government action. And only, of course, means only. Next section, .024. The judgment shall order the government entity to rescind the governmental action within 30 days. and .044, that if you don't do a takings impact assessment, you can sue for declaration of invalidity. So the only remedy in the chapter is to invalidate the governmental action. That only works with regulatory takings.
Mr. Brister, what about the clause that says in addition to other procedures or remedies provided by law?
I'm not sure what you're referring to. I mean, it says these are in addition to, but when it says you're only, if you sue for taking of the chapter, you're only entitled to invalidation, that means that doesn't sweep in damages. You can't, because otherwise they wouldn't have said it only applies to this. Those remedies, invalidating, rescinding.
006A is what I was thinking of. Sorry, I didn't have it in front of me.
006A.
2007 006A.
Right. Says there the provisions of this chapter are not exclusive. The remedies, but the remedies provided by the chapter are in addition to other procedures. So it doesn't disqualify your constitutional takings claim, but the statute, the chapter says the only remedy you can get under this chapter is invalidation. Invalidation obviously doesn't work with anything other than regulatory takings. You can't invalidate
about that, counsel. The statute assumes that there's a dispute about whether a taking has occurred at all, which you would rarely have in a physical taking situation where the government is asserting ownership over property. But if you did have a situation like that where the government had engaged in a sort of traditional physical taking and it was denying that a taking had occurred, wouldn't the statute operate to fix that problem?
If it is something that could be invalidated or voided, yes, but that's the only remedy that 2007 authorizes. In fact, as the state's going to argue in a minute, it's the only waiver. Says the statute waives immunity only for remedies to the extent of the chapter, only for liability under the chapter. You can't be liable for a taking. That is a fact finding according to the statute. The only thing you're entitled to and the only thing the agency is liable for is invalidation of the government action.
Well, but then the government entity is put to the choice of either rescinding its taking or paying the damages, which is sort of the same choice that it would have in the first place in a physical taking situation. Are we going to back off and not do this at all, or are we going to pay just compensation? And so it seems like it would work in a physical taking situation if the government was denying that a taking took place.
One can imagine the statute working in all kinds of ways. The problem is the legislator says if you find a taking, the owner is only entitled to invalidation of the government plan. That's all you're entitled to. There's no other way to construe that only other than only.
Do you agree with the state's points about redressability and the standing problem that the state raises? Do you agree with them?
Yes, we agree with all that. We don't think you get there because that is an argument based on the waiver clause in the chapter. If the chapter doesn't apply, it doesn't matter what the waiver clause says. We think the chapter cannot apply, looked at as a whole, to anything but regulatory actions. So we agree with what they say, but we think the bigger problem is the chapter doesn't apply to non-regulatory emergencies. If I can move briefly in the time I have left to the listed emergencies. Plaintiffs, we've listed those. That's on tab B. This is the does not apply to. That's on tab B. Plaintiffs say, well, that only counts if you never pleaded. If that would apply if we had pleaded that the River Authority had a reasonable good faith that its acts were necessary, or admit that it imposed a burden that was no greater than necessary. And that's simply a position that the plaintiffs have to plead themselves out of court. And that's not the case. We've detailed in our reply brief the things that they said that showed why the River Authority did what they did. But the additional problem
those
is
things, Mr. Brister, established that that the rate at which the water was being released from the dam was based on a reasonable good faith belief, and isn't that part of the dispute in this case?
well, if here's going to be the problem. If the exclusions don't apply, you have to meet the statute. The statute says you have to have a takings impacts assessment. You have to have a 30 days notice in the newspaper. So if the governor declares, says that bars have to close, was there taking, or a court declares that there's no evictions cases or no jury trials, was the takings impact assessment done? Was 30 days notice given in the paper? If this applies, you're going to have big problems. My view is plaintiff's got to do more than just, well, we didn't plead that you were reasonable. I think the plaintiff has to plead specifically that you were unreasonable. I see that my time's up, and so I'll yield to the Attorney General.
Any other questions? Thank you, Mr. Brister. We'll hear from the state.
Mr. Chief Justice, and may it please the court, Jason LaFawn for the state of Texas. The Act's only remedy for a taking is invalidation and rescission, which is meaningless in a case like this, arising from an alleged taking wholly in the past. The Act's limitations mean that 1, plaintiffs lack standing to pursue their statutory claims, and 2, the Act does not clearly and unambiguously waive sovereign immunity for plaintiffs' claims. Plaintiffs lack standing because, as this court put it 2 years ago in Myers, there is no remedy that the trial court could fashion against the defendant that would afford relief for plaintiff's alleged injury. The taking that plaintiffs allege here has already occurred. There is no way to unwind the release of water from Lake Conroe, and the only relief that can redress plaintiffs' alleged injury and the only relief they seek in their petitions is an award of damages, which the Act does not provide.
Counsel, what are we supposed to do with 006A? How do we read that together with 23?
Your Honor, you read that to mean that a plaintiff can sue if they have a proper claim under this statute, and they can sue under any other statute. The best way to read that is the legislature clearing the way to allow property owners who have a proper claim under the statute to sue. I think that that's the best way to read that in the context of the entire statute. And as this court said in State Bar of Texas v. Gomez, because the district court cannot effect a remedy that would resolve this dispute, the case does not present a justiciable controversy. Indeed, this case is just like—
Counsel, I understand your point about the lack of redressability here, but what they would say, I think, is that they want a declaration, essentially, that this was a taking and that it's valued at a certain amount. And your point is that, well, that wouldn't directly redress their injury. But I wonder whether there's a similar redressability problem with a lot of declaratory judgments that are not self-executing into injunctions. Would you say that in general, there's sort of a latent redressability problem with declaratory judgments because they don't actually do anything besides declare legal status?
Well, Your Honor, there is tension as compared to an injunction, but you don't need to reach that tension here because this court has already said that what a declaratory judgment must do is look to the future. So in Garcia, the court said that a declaration about acts in the past would do nothing for the plaintiff's injury there. Whereas a declaration about current or future acts, although it doesn't have the threat of contempt, it is still a court order about actions that are going on. So this case is even farther away from that and falls under Garcia. And this case is also just like City of Rockwell, in which this court held that because the statute sued under in that case did not provide the relief that the plaintiff sought, the plaintiff lacked standing. The Act's limited remedy also means that plaintiffs' claims are barred by sovereign immunity. The Act's waiver of sovereign immunity is tied to the reach of the Act's liability, and the Act expressly limits its liability to invalidation. Now, plaintiffs have sought an award of damages, which again, the Act does not provide. And as this court has held multiple times, Town of Shady Shores, Zachary Construction, and others, when a waiver of sovereign immunity is tied to specific relief, as it is with the Act, a claim seeking additional relief is barred by sovereign immunity. In addition to that, if you look at the whole Act, it simply does not make sense for the Act to apply to an alleged taking that occurs wholly in the past. The Act, every part of it, is prospective and prophylactic. And because the only liability and the only remedy that the Act provides for an alleged taking is incapable of execution for a taking that has occurred wholly in the past, the Act's waiver of sovereign immunity cannot clearly and unambiguously encompass plaintiff's claim.
Mr. LaFond, if this case involved a regulatory taking so that Chapter 2007 applied, would the claim for inverse condemnation, assuming that you could meet that, it was complete regulatory taking, would you agree that both of those claims could proceed in separate courts, or are they all, completely alternative forms of relief?
Theoretically, Your Honor, they could proceed in courts at the same time. I think that's what the legislature was getting at with its cumulative remedies provision. Now, whether that would actually happen in practice, I think plaintiffs would, if they could, they would prefer to sue under the statute because it has fees, and you can either stop the taking and try to get damages. You can sacrifice that to seek just damages and be guaranteed damages, but then you don't get the fees. So I don't think that you would always have these parallel claims, but it is something that I think is contemplated under the statute. And if there are no further questions.
Any other questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Mr. Marable will present argument for the respondents.
May it please the court, opposing counsel. Justice Lehrman, you, I believe, asked the first question during Mr. Brister's presentation, and your question had to do with, doesn't the statute clearly apply to physical takings? And the answer is yes. And in the oral argument exhibit that I filed yesterday, the AG, in the guidelines that it publishes to the various governmental entities, it states that the statute is basically coextensive with the constitutional provisions of both the state constitution and federal constitution, which includes non-regulatory physical takings. And in the footnote that I've highlighted in the oral argument exhibit, the AG actually cites to this court's decision in Gregg, which is a non-regulatory physical taking flood case. And the argument that Mr. Brister had is that he relied upon the damage provision to argue that it doesn't apply to the physical takings. And that issue came up in several of the questions, I believe, that were asked by the panel. So I'm going to address that. I believe Justice Boyd asked a question about the various procedures and remedies questions. And I believe there was some discussion about that in answer to Justice Boyd's question. Under the reasoning of Mr. Brister and the AG, they say that you cannot litigate a physical taking under the statute because the statute talks about rescission. The statute talks about three things. It talks about invalidation of the governmental action. It talks about the judgment, which shall say that the action shall be rescinded. And then it states that the plaintiff is entitled to a fact finding as to the amount of damages, and it gives the governmental entity the option of paying damages, and specifically says if they pay the damages, it is a waiver of sovereign immunity under the statute. There was a question about a and I forget which justice asked the question, but it had to do, what if you've got a dispute about whether or not there was a taking? Doesn't this statute provide a remedy for that? And it clearly does. You can assert both a constitutional claim and a statutory claim, and you can get the determination as to whether or not there was a taking, and then you proceed to the issue of damages. Now, the argument—
If the government takes your house and then says that wasn't a taking, this statute allows you to establish that it was a taking, and then the government would have to either give you your house back or pay you your damages. It seems here that it's not possible. I mean, it doesn't make any sense at all to talk about rescinding or invalidating the flooding of these homes during Hurricane Harvey. That's just a nonsensical concept. So how do you apply a statute that speaks in those terms to a situation like this?
The provision of the statute, which talks about Justice Blacklock with the rescission, it's 2007-024, and it's two parts. It says that the court shall order the rescission, and it also says that the court shall include the fact finding as to the damages. Mr. Brister discussed City of Keller versus Wilson, which he described as a regulatory physical taking case. There are clearly physical taking cases that can be both regulatory and non-regulatory, and they can be completed. And I'm trying to get directly to your to answer your question. So if the regulatory physical taking has been completed, then the same argument applies according to the AG and to Mr. Brister. Well, you can't sue under the statute because all you can do is order rescission. It's clear that there are certain things in the regulatory context that a court could order rescission, and the court could order an invalidation. You can make a ruling that a completed past physical taking, whether it's regulatory or non-regulatory, is invalid if the jury and the court, because it talks about a fact finding, if the jury finds that the regulatory taking caused physical destruction or the non-regulatory taking caused physical destruction, you're entitled to a fact finding that there was a taking, and you're entitled to the provision within the statute which says that that's invalid. So then you come to the issue.
The statute also says that the judgment shall order the governmental entity to rescind the action. How can a court applying this statute comply with that? How could a court order the rescission of the flooding of homes that took place years ago?
I think the way that plays out, Justice Blacklock, is that the judgment recites that it shall be rescinded, and then it recites the provision dealing with the damages, and it puts the governmental entity to the choice as to whether or not they're going to pay those damages. Because if it's completed, I tend to agree with you that conceptually you can declare it invalid. But if my home's been washed away from the water, either under City of Keller versus Wilson as a regulatory taking or a non-regulatory taking, they really can't put my house back. But the statute says that they are supposed to include the finding as to rescission. And I think the reason that it's in there is because there obviously are a lot of regulatory takings, which the statute was clearly intended to apply to, which could apply to a situation where the governmental entity is put to the choice and says, okay, we're not paying you damages. We're just going to rescind this and go that route. And I think this kind of leads to a question that Justice Bland asked about how a constitutional and statutory claim can proceed. And Justice Bland was talking about in different courts. They proceed in different courts only, I believe, in Harris County because of the situation that we have with our county court jurisdiction, district court jurisdiction. The way the statute reads, and this was an issue that was raised by Justice Boyd, this was not intended to be an exclusive statutory scheme or cause of action. Any place else but Houston, I can assert a constitutional claim, I can assert a statutory claim under 2007, and I can proceed with both of those. And in the situation, Justice Blacklock, that you were talking about, whether it's a completed regulatory or non-regulatory, I ask the jury to decide whether there's a taking. In my constitutional claim, they're going to award damages. In my statutory case, they're going to order rescission and have the damages option. Now, the reason that the statutory provision is important to plaintiffs like the respondents in this case for asserting these types of claims is that there's additional relief that the plaintiffs can obtain under the statutory provisions. One is attorney's fees are recoverable under the statute, 2007. The other thing is there is a bright line rule within the statute which says that it is a taking if your property has been damaged for more than 20% of its market value. There is a dispute in the constitutional cases as to whether or not you can recover damages for a destruction of your property if it's not substantial. And that's even in the footnote of the AG's guidelines that I've highlighted. And so the statute takes that issue out where you wouldn't even have to litigate it in a constitutional case. So there is symmetry between having the claims asserted together. We just can't do it in Harris County because of the unique nature of how we treat inverse condemnations in response to both your question, Justice Bland, and the Justice Blacklock in terms of how do we deal with the fact that it's a completed taking? Because if that precludes any relief under the statute, then you can't get relief for either a regulatory physical taking or a non-regulatory physical taking. And Mr. Brister and the SJR's papers are adamantly clear that this statute does apply to non-regulatory physical takings because the statute has that language. Justice Busby, you asked a question about the factual dispute about the amount of water.
Before you get into that, Mr. Marable, let me ask you a question about the statute, the point you were just talking about. Say we have a temporary regulatory taking, and the statute expressly says that it applies to temporary takings, and that has concluded before the time that the case is brought to court. What's your view on, I mean, obviously in that situation, you couldn't rescind the taking because it's already finished, but I take it your position would be that you could still declare it invalid looking backwards and then establish a fact finding on the amount of damages?
The answer is yes, and that is the structure of the statute. The structure of the statute deals with multiple situations. It deals with takings. It deals with proposed action is the actual term in another section of the statute. And the takings definition clearly deals with both enactment of ordinances and enactment of provisions, which is prospective. And it also deals with a situation where you can file a case and argue that there should have been a takings assessment, an impacts assessment. So in your situation, you have a temporary taking that's completed. You can file a takings claim for that because it satisfies the takings claim. The statute says that you get a finding as to whether it's a taking, and the statute says that if it's a taking, it's to be declared invalid. We can argue even if it's completed. I think that conceptually, if it's wrongful, it's invalid. So I don't think there's any problem under your example as to whether you can declare it invalid or not. As part of the determination of whether there's a taking, it says that the court is supposed to determine whether there's damages, just like you would in a constitutional case. And then you get to the issue that you're talking about in terms of the judgment. Because if it's a temporary taking and it's done, then as Mr. Brister says, how do you unring the bell? And I'm not sure that you can unring the bell. You could, obviously, in some cases in which the damage has not occurred and it is either prospective or it is going to occur within a certain amount of time. But there's obviously a lot of takings. If they tear down the house, you can't rescind it. You can't order them to build a house, but you can make the rescission order in the judgment, like it says, and you have the damage provision, and then the entity decides whether they're going to pay the damage provision. Because if they decide not to pay it, and it simply says that they are to rescind it and they can't do it, I don't believe a court can enforce the governmental entity to engage in an act that it's unable to perform. But obviously the statute was written broadly to deal both with situations where you've got proposed takings, proposed action, temporary action, and final completed destruction under both scenarios. Justice Busby, you asked about the issue, and I think this relates both to the question you asked and Mr. Brister's argument about the emergency. Mr. Brister cites a Texas Tort Claims Act case that he wrote the opinion on when he was on the court involving the city of San Antonio when there was a flood. And the Texas Tort Claims Act has an absolute provision that says no Texas Tort Claims Act liability if you're responding to an emergency. And so San Antonio declared an emergency, the policemen were responding, no Texas Tort Claims Act liability. There is no Hurricane Harvey or disaster declaration, which they want to rely upon, either from the federal government or the state government, which says that if you take action under or while there's a declaration of a disaster, that that's an exception or some type of defense to a takings claim. The provisions that they are relying upon, which they are now relying upon for the first time in this case on appeal, deal with whether or not they had a reasonable good faith belief. And there's also a balancing test in the other one, which are classic factual questions. This court in the Rusk versus Black case made very clear that if sovereign immunity arguments are made for the first time on appeal and the record is not sufficiently developed for the plaintiff to be able to respond to it, you got to remand it back to the trial court to address that issue. I think that based on the way this case is postured, Mr. Brister is relying upon judicial notice, which is prohibited under Rule 91A, and he's asking you to take judicial notice in his reply brief on the merits of disaster declarations. I don't think they get him to the provisions that he's asking for as a matter of law, but the general rule is that this court cannot consider evidence on appeal unless it's a subject matter jurisdiction issue. For example, if the case is moot because it's settled, I can file evidence under the government code to establish that there's no case or controversy. But
Counsel, how do you deal with the standing arguments that the state makes, the redressability problem? The statute directs the district court to give the government the option of either rescinding it's essentially how it ends up working is that the government has the option to either rescind the taking or pay the damages. And we've got a situation here where if the government chooses to rescind the taking, that's a sort of a nonsensical concept. It's not possible to do. So they choose that option and you've achieved nothing. I mean, nothing has happened for your clients. You've gotten all the way to the end of the application of this statute and there's no injury has been redressed because the government elects rescission and and nothing happens since rescission is impossible. Why doesn't that create a standing problem here?
Because the statute obviously provides for a waiver of sovereign immunity in I believe the way it's quoted is to the extent of liability in this chapter, which is the similar provisions that this court has addressed. And I apologize exactly the case site. It's the one, I believe it's HB Zachary. There was a similar provision. And what ends up happening is that type of sovereign immunity provision devolves to the merits. And so we have a provision within the statute, which is 2000-024, that says that sovereign immunity liability is waived to the extent that the governmental entity elects to pay compensation under this section. And so the fact that I have a remedy that may not come into effect until the government decides to do it, that's an express waiver of sovereign immunity. And it may be
a waiver of sovereign immunity, but that doesn't mean that it's a remedy that redresses your client's injury. How is application of this statute going to redress your client's injury in the end?
Because I have a damage remedy which is coextensive to what I could get under the Constitution, and if I get a finding of that there was a taking and that it's invalid, which is what the statute says, I can recover attorney's fees, and that's built into the statute. So even if
so on the recovery of attorney's fees, would you can't get a finding of liability for damages. So what's the underlying liability here? Would it be for the rescission remedy, the alternative rescission remedy that's sufficient to trigger the claim for attorney's fees, and that thus affords you more relief than you could get from an inverse condemnation? I'm just trying to figure out how that works.
Yeah, and I didn't mean to interrupt you. I apologize, Justice.
No.
The statute gives you the ability to sue for the taking, and so if it's a taking, and in this case it's a constitutional taking, I can assert a common law claim under the Constitution, and I can assert the statutory claim. Once I assert the statutory claim under Chapter 2007, it proceeds as a factual question, because it says that whether there's a taking is a fact question. The court submits it to the jury. The jury says taking, not a taking, under the definitions that are within the statute. And it says if I get a favorable finding, then the statute says that I'm entitled to a ruling that it's declared invalid. And so I have succeeded in that regard under the statute, and the statute says that if I'm successful in that regard, I get attorney's fees, which I cannot get in a constitutional claim. And I apologize, Justice Bland, I have run over my time, but I hope I tried to answer your question.
You did.
Any other questions? Thank you, Mr. Marable. Mr. Brister, I believe you have 5 minutes.
Thank you, Your Honor. Let me say, I think it's going to be difficult to write.
To address that last point, that the constitutional takings claim doesn't afford complete relief because there are additional remedies available under the statutory taking that are not available, like attorney's fees.
Sure. So that's the second half of Section .006, the cumulative remedies. So the provisions in 2007 are not exclusive. They're in addition to other proceedings, but Part B says a person cannot recover under this chapter and also recover under an action in common law for the same economic laws. So yes, you can have duplicate cases, and it's more than just Harris County where you're in duplicate courts, because the same division of eminent domain cases happens in Bexar County, Travis County, Fort Bend County, other counties. But the problem is you can only recover once. And nobody in their right mind for their client is going to recover rescinding a past flood and waive their constitutional claim for damages. That's why I think it has to be read as a regulatory issue.
Your point is that the constitutional takings amount you can't add fees by picking and borrowing from the statutory claim and the constitutional claim?
I hate to be old fashioned, but when the legislature says the owner is only entitled to invalidation of government actions, that means you're only entitled to invalidate the action.
But why
Which doesn't
can't you
do
do that for an action that's already been completed, like a temporary regulatory taking?
Yeah, well, that may be a great way to draft the statute. The problem is,
Well, the statute says that you can get relief for a temporary regulatory taking, which is
Right.
one that's already been completed. And it says you can get a declaration of invalidity. So why couldn't you declare that invalid looking backwards?
you could, and the statute could have been written that way. The problem is we're looking at a list of 20 things that it applies only to. And some of those, we can't read into, I don't think, that list that it applies only to things that can be taken back, that aren't completed, and things that are. It can be read as a list where under the standard rules of words in a list,
Let's look at
it's regulations and regulations.
Use of permitting, citations, orders, or other similar means, those can have a limited duration. So if they say you can't go on your property at all for 30 days and that's expired by the time it comes to the court, I mean, I think that clearly would fall under A4 if you're enforcing it with a citation or an order. But why can't you get a declaration that that was invalid? Yes, you can't rescind it, but you can also get a remedy for a finding of damages under 024B and a finding of invalidity under 023, it seems.
Because you can't recover damages.
Well, you can if they elect to pay.
Sure, you can, if they elect to pay, you don't need the statute at all. The statute says you can only recover damage. We're only liable for damages. And a finding of damages in this case doesn't help you because you have elected, if you recover under this, a statement of a finding of fact of damages, you can't file a condemnation action and collect the damages. You can recover once for the same injury. Under the statute, not under the statute. So you don't gain anything. Is that an
election issue, not a standing issue?
Again, we did not assert standing because we think the statute doesn't apply. The standing argument that the Attorney General makes is the waiver clause within the statute. If the statute doesn't apply, it doesn't matter what it waives immunity for. I just have a few seconds. And so I will just move to my close unless the court has another questions. The problem is courts don't have the power to order hurricanes to retreat or floodwaters to recede. I recall, as you know, that many courthouses have Moses up on the wall with tablets, among other lawgivers who gave us law codes. But he didn't descend the mountain with the power to order the Red Sea or the Gulf of Mexico to recede. This statute does not give them what they want. It only gives a rescission, and there's nothing that allows to do that. The question of how the court gets there, we think the best construction with the most textual support is that it simply doesn't apply to regulations and leave the other questions to another day. Unless the court has questions, that's it. Thank you.
Any other questions? Thank you, Mr. Brister. The case is submitted and the court will take another brief recess.
Good job, Vincent.
Thank you very much, Justice Brister.
And Jason. Enjoyed working with